I guess I'm just thinking through the moves that you're making, and I think you are making, to my mind, a credible argument that there's a legitimate government interest in solving crimes. Leave aside the question of precisely what the relationship is to particular investigative techniques and whatnot. But it is not especially important in your argument that probable cause determination has not been upheld by a judge. That doesn't matter. It's not important in your argument that an arrest could be wrong. You've given us some good reasons why we shouldn't look only to this statute to assess whether the law tries to do something about pretextual arrest. I get all that. Why stop at arrests? If these interests are legitimate, why not allow DNA to be collected at a Terry stop?
Well, Your Honor, if I can answer the question, I do want to make sure I save time for rebuttal.
You'll have 7 minutes for rebuttal if you finish on answering this question.
Sure. The balancing conducted in our brief and by the majority in King was specific to an individual who was subject to a lawful custodial arrest and being processed at a jail facility. And I think that the privacy side of the balance would be dramatically different if you were talking about people in other circumstances, people who are at liberty or even subject to a Terry stop. And that is a reason why this court shouldn't decide this case based on hypotheticals about other types of situated people who would be subject to a different type of constitutional balancing.
This is important. I'm sorry. I'm going to persist. Are you hinging your case on the notion that Mr. Bouza was subject to a lawful custodial arrest?
Your Honor, I think that the legality of the search turns on the fact that he was subject to a custodial arrest. And I think that if it turns out that the custodial arrest is later found to be unlawful, then two things. First of all, that person under our statute will be eligible to have the sample and the DNA identification profile expunged. And that might be the sort of rare circumstance where there might be some sort of constitutional interest going beyond the statutory protection in having the sample destroyed. Generally, courts have held that there is no constitutional right to have identifiers collected at a lawful custodial arrest expunged. But the circumstance might be different if you're dealing with somebody who, after the fact, a court held the arrest was not lawful.
But at that point, the state, in a sense, has gotten some or all of the benefit of whatever DNA analysis that it could conduct, especially if the time, as you suggest, to usefully analyze DNA is shortening every day.
You're right.
So what happens downstream just matters less and less over time.
I understand the point, but I think that the same can be said of fingerprints and photographs and other identifiers that have always been collected by from arrestees at booking, and that's been understood.
So if we're in the world of generalized balancing, which is what you said the way the court should analyze this case, Justice Cuellar has posed to you, forget about 60,000. Why don't we go to Terry stops? Let's go even broader. You resisted, I think rightly, you resisted that move. But I'm wondering, why is 60,000 the right number? Why shouldn't there be a more limited screen in terms of the balancing of general interests here? That you're suggesting, well, for 60,000 people whose felony arrests end up in nothing, that's just too bad for them. It's not that those arrests were done in bad faith or pretextual. It's just that that's the way the system is. There's a lot of discretion. And you can imagine what kind of communities will be affected. Who are those 60,000 people? And why don't we apply a slightly more precise screen in terms of a little more limited class of felonies, or wait for a probable cause determination, as the contingent statute waiting in the wings suggests? Why is 60,000 the right balancing of these interests?
Well, Your Honor, if I can answer, and I do want to make sure I save some time for rebuttal, I think that you're making points, and those might be points that informed the policy decision-making process in states like Maryland, who have adopted somewhat narrower statutes. But they haven't been viewed by this court or others as having constitutional significance. The general approach of the courts has been that it is reasonable when an individual is subject to a custodial arrest to collect identifiers from that person, to retain them in state databases, and to use them to serve legitimate government interests.
I'm so sorry to keep you up there. I hope that you'll get the time that you need for rebuttal, but do want to ask one follow-up question on Justice Liu's question, which is in a scenario that we're most concerned about, in which there's a pretextual felony arrest, regardless of whether or not the suspect has committed some other lower-level crime. If you're willing to acknowledge that there could be an as-applied constitutional challenge to the retention of the sample, I'm wondering whether there isn't also something that suspect would have to say about the use of that sample in the interim in any kind of downstream prosecution.
I guess as I stand here at the lectern, I don't know what the answer to that question is, Your Honor. I think that it would be an issue that could be reviewed on a future as-applied challenge, but it's not an issue that's directly implicated here, and I think it would make most sense to wait until those types of hypothetical scenarios posited by the bench and by amici in this case develop, rather than deciding this case on hypotheticals.
So, Mr. Mongan, you'll have 4 minutes for rebuttal.
Thank you, Your Honor.
Good morning, and may it please the Court. In applying the independent provisions of the California Constitution, this Court should not take the much-disputed 5-4 opinion in King, which is subject to criticism even on the terms of the Maryland statute. This Court should not take that rationale and then extend it to the different and more intrusive provisions of the California statute, several of which have already been addressed.
Let me ask you a question about the Maryland process. Is it true that in the Maryland process, the police file the criminal allegation rather than the prosecutor?
It appears from the statute that, or not from the statute, but from a Maryland rule that may be possible. But it is definitely the case in Maryland that although the sample is collected at the time of arrest, it cannot be transmitted to the laboratory until there has been a judicial determination of probable cause.
The other difference between the California statute and the Maryland statute is that the Maryland statute says violent and some other adjective.
That's correct, Your Honor.
And our statute says felony, correct?
Yes, that's
and
right.
In this case, the arrest was for arson?
That's correct, Your Honor.
And that is covered under the Maryland statute?
I believe that a violent offense like that likely is covered by the Maryland statute. There is also since we mentioned two of them, there is a third distinction between the Maryland and the California statutes, and that's in the area of expungement, with the Maryland statute making expungement automatic, whereas, as we've discussed at some length in the briefs, in California it is anything but automatic.
But there is a process to expunge it.
There is a process of which an arrestee is never even given notice.
And in addition to that process, has the Attorney General or Department of Justice set up a protocol in which to expunge those samples that where there is later no legal process, no conviction?
If one is aware of the existence of the process and looks on the Attorney General's website, there is a form. But that form requires the arrestee to go out and get various kinds of documentation, which frankly I would think would be daunting even for many lawyers, but especially for an arrestee. The principal document being for an arrestee who sort of comes at the confluence of these distinctions, which is someone who wasn't even charged. That arrestee has to go to the district attorney's office and somehow get the district attorney to file a letter stating we are not going to charge this person.
Surely your objections are not only about the notice process and that administrative rigmarole, right? I think they go
It is
deeper.
about the fact it's not automatic, Your Honor.
Okay, so let me ask you a question about the California Constitution. Since we'll have plenty of occasion to talk about Maryland v. King, we have, but the California Constitution applies not just on the weekdays, not just on Tuesday, it applies all the time, right? So
Absolutely, Your Honor.
for 7 years, People v. Robinson has been on the books, and we've held that it's no problem under the California Constitution for a person convicted of a crime in prison to be compelled to provide a DNA sample, correct?
That's correct, and there's no debate over that.
So walk me through why it shouldn't matter, I think this is your argument, that somebody is ultimately convicted under the California Constitution. Why instead, even somebody who is convicted, I assume, still has rights that we should care about before they're convicted.
Exactly, Your Honor. That's a principle that permeates our law. We evaluate the legality of a search based on the circumstances at the time. And to go to directly to a question of the Chief Justice.
Need to know what those circumstances are. I mean, there's also a competing principle of judicial review, which is that unless we're talking about a facial challenge, and I'd love to hear how you would characterize the challenge. In an as-applied challenge, we look at the circumstances of the particular case before us without sort of hypothesizing about how a particular statutory regime might play out or other challenges that might be brought to that statutory regime in other cases that implicate other circumstances.
Ours is an as-applied challenge under these specific circumstances.
So can I ask you a follow-up on that? So as an applied challenge, Mr. Booza's circumstances compared to Maryland, as Justice Chin pointed out, Mr. Booza was convicted of a violent felony, arson. So he falls under and gets the green light under the Maryland Act. Secondly, his sample was transmitted and analyzed not only after a finding of probable cause, but really after a finding of proof beyond reasonable doubt, because he was found guilty of that arson, and then afterward his sample was collected and transmitted. So under an applied challenge, Mr. Booza falls under Maryland statute. He gets the green light again. Now, in an applied challenge under Maryland, the automatic expungement wouldn't apply to Mr. Booza because he fits the other two. So I'm not sure how you win on an as-applied challenge.
Your Honor, let me dispute some of the premises there. To begin with, at the time, law enforcement demanded that he provide a sample, and he refused. As of that time, he had been arrested, but there had not been any judicial determination of probable cause. He had not been arraigned, there had not been a warrant, there had not been a Gerstein-type paper determination.
So you're saying that you can't even ask because that would be unconstitutional.
You can't demand it. You can't penalize him for refusing what at that point was an unconstitutional search, because we don't determine the legality of a search or a sought search based on what happens later. So the fact that he was later convicted, and when he was convicted, he acceded, he gave a sample. But we're evaluating here the legality of his misdemeanor conviction, 298.1, which was explicitly predicated under the state's evidence at trial.
Could you please answer the Chief Justice's question regarding the expungement? There was a conviction, correct?
There was a conviction, but there too, we have to analyze the situation in terms of his position at the time of this event. At the time of his event, we don't know whether in the future.
But that is in essence your answer also to the as-applied versus facial challenge, which is that it's not that that terminology really matters greatly. It's that the point is we have to evaluate the claim at the time that the cheek swab was requested, and it's because the statute is written the way it is. Immediately upon arrest, as soon as practical upon arrest, all these early points, none of which are predicated upon conviction or probable cause findings or any of that, none of that has legal significance to the way the statute works in terms of commanding the buccal swab at the time. That's what we have to evaluate.
That's correct, Your Honor. Before he's been charged, before he's been arraigned.
It doesn't really matter whether we call this as applied or facial. It's just that's the way the statute works.
Yes, Your Honor, that's correct.
Statute as applied to Mr. Booza made no distinction with respect to what was going to happen to him.
Exactly, because it was unknowable at the time. And under those same crimes.
So you're saying there's no difference in standards of review for an as-applied versus a facial constitutional challenge? And if so, could you cite some authority that says there's no difference?
Your Honor, I think, and this is actually something where I have some agreement with a statement by the Attorney General. In this context, it is as applied in the sense that we have to look at the situation at the time the search was demanded. But that, in turn, requires us to look at the statutory regimen which Mr. Booza was facing when this search was demanded of him. And that requires we consider everything, including the fact that if he did prove to be among those roughly 1/3 who are not convicted, there would be no automatic expungement, that if he was one of those roughly 17% who are not even charged, the sample's still going to be taken, and in contrast to Maryland, it's going to be already transmitted to the Department of Justice labs, rather than in Maryland, where if you do not get to a probable cause determination, that ends it. It never, in fact, you don't even have to worry about expungement because it's never transmitted in the first place.
It seems your point then is that Mr. Booza, in this case, as the statute applies to him, is simply in the shoes of any felony arrestee as the statute applies to any felony.
That is correct, Your Honor.
So the as-applied versus facial distinction, which of course has a lot of, that has a lot of bite in other contexts. Mm-hmm. In this context, it's because the trigger is so light. It's felony arrest, that's it. So there's nothing differentiating Mr. Booza from any other felony arrestee. And so, in a sense, as applied to him is as applied to everyone. The statute.
Yes, Your Honor, and if I could just add one additional factor, he's any felony arrestee pre-charging, pre-arraignment.
Right, but at booking.
Pardon?
But at booking.
Yes, that's correct, Your Honor.
Not as though the sample had been collected in the field.
That's correct, Your Honor.
He was taken to the detention facility.
But I think
Another question. Since 2013, since the King decision came out, which was 5-4, which has not been a great surprise for many years, has there been any other high court, state high court, that has not followed Maryland versus King?
there absolutely has, Your Honor.
I'd like to read the background on those cases.
Yes, that's the Vermont case of State versus Medina, which is cited in our briefs. It came out in 2014, and Vermont, like California, has a tradition of construing its state search and seizure clause independently, and virtually all of the considerations that we've been discussing as far as defects in the King opinion were aired in the Medina case, including what Justice Liu referred to as the wordplay of the identification rationale, which is so central to the King rationale. But in one respect, the Vermont Medina case was an easier one, was a more difficult one than this, because Vermont's statutory scheme was closer to Maryland's than California's, in the sense that the sample wasn't transmitted until after arraignment.
We've said some things in our opinions over the years that might be charitably described as not always completely clear with respect to how we analyze state constitutional provisions that have similar wording to federal ones. But how would you describe the proper mode of analysis of state constitutional rights in this case?
Your Honor, as when confronted with a Supreme Court decision, let me also preface this, as I said before, that the little tweak to it is, in this case, it's not a binary, do we follow King or not, because we're dealing with a different statute. So the question is, are we so confident in the soundness of the King majority's rationale that we want to extend it to a statutory regimen in which the balance is substantially different. But like any Supreme Court decision, like the dissenting opinion, like a decision of the High Court of any other state, such as Vermont, the King majority opinion is subject to respectful consideration by this court, as this court said in Brizendine. Among the considerations that this court has looked to in whether or not to adopt, for California Constitution purposes, a Supreme Court decision, one of them is, was it divided or was it unanimous? This, of course, is a 5-4 opinion. Was it subject to academic criticism? I'd say it's pretty clear.
You're not suggesting that we don't follow it.
Pardon, Your Honor?
Are you suggesting that we don't follow it?
I'm suggesting that in deciding whether to adopt it as the court's own rationale for purposes of the independent search provisions of the California Constitution, this court, as it has done before in Brizendine, Ruggles, Liwa, should look at these considerations, and it is free if it believes.
Let me ask you another question about the expungement process. We talked about the California process of expungement. We talked about the process established by the Attorney General, our Department of Justice. Isn't there also a third process that was established by the FBI under CODIS if there is no charge or no conviction?
As my understanding, Your Honor, is that is in the FBI's protocols, but it's not a process that one can do through. The FBI leaves it to states to actually carry it out. In fact, as Justice Klein's opinion for the Court of Appeal commented, it's not clear whether California's regimen of not having automatic expungement is in compliance with the FBI, or that there's any remedy for it. But there is not, as far as I'm aware, a mechanism by which a California arrestee can have a former arrestee who was not convicted, can have his DNA sample and profile expunged, except by following the California statutory procedure.
Could I ask you, counsel, would you be satisfied with these contingent provisions that the legislature has enacted?
Let me put it this way, Your Honor. First, I think this court, since it doesn't want to be in the business of issuing advisory opinion, needs to decide the case on the basis of the regimen in place when Mr. Buzzo was attempted search occurred. But my position, since Your Honor has asked me, is the contingent statutes mitigate but do not resolve the infirmities in the California statute. And the reason for that is, yes, I mean, I will readily concede that the contingent statute is a huge improvement in, number one, not having the DNA transmitted for that very substantial portion, maybe 17% who aren't even charged, and number two, for ensuring that of the greater number, the 33% who aren't convicted, that their DNA is promptly expunged. So that's great. It doesn't entirely solve the problem for this very reasons stated in Justice Scalia's dissent, which are inherent to any regimen that predicates the search and transmission of the sample upon arrest rather than conviction.
So the contingent statutes would bring the regime a little bit closer to Maryland.
Yes, yes,
it would, Your Honor. Within the bounds of Maryland versus King. But your first argument is that we don't even need to go there because King is distinguishable on these other aspects, and the California statute is simply broader.
Yes, Your Honors. The way I would articulate it is the court doesn't need, for purposes of this case, in contrast to some past cases where this court has actually explicitly chosen not to follow, for California law, a directly on point Supreme Court decision. The decision here is not so acute because the question is, bearing in mind both the criticisms of the King majority and these several distinctions between the statutory regimens, is the court going to not just adopt that rationale, but extend it to a regimen in which the balances, in which is less tightly tied to the asserted governmental interests, and which is far more invasive of privacy based on the very statistics that Your Honor cited, the fact that we have roughly, based on the 2016 statistics, about 70,000 people a year who are arrested, aren't going to be convicted, and within that group, about 36,000 not even charged. So those are compelling reasons why the court doesn't have to say, were we the U.S. Supreme Court, we would have decided King differently. The court simply has to say, combining these reasons for caution about the King majority with these several distinctions.
So before you go forward, let me backtrack, because I think, we decided the Robinson case, the California Supreme Court. That was a case that started out as a Doe warrant.
That's correct, Your Honor.
Started out as a statute of limitations running out on a serial rapist. And at that point, then, the prosecutor issued, because they had semen, they did a DNA sample. They got the profile. They used that in the warrant, that it helped to toll the statute of limitations on the serial rapist. Eventually led to Mr. Robinson's arrest. This court upheld it. In the Robinson case, we looked at the privacy clause of the California Constitution, and we said in Robinson, like other federal cases had said, that an accused loses any claim of right to privacy in their identification once they are arrested and booked, once they are in lawful custody. We didn't at that time talk about a judicial determination of probable cause. We determined, though, at that point, identification was paramount in the lawful custody area. So if we go with your rule and construe our California Constitution as providing greater privacy and therefore invalidate the Voter Initiative DNA Collection Act, what do we say about privacy, and what do we say about Robinson and an arrestee's right to...
Well, Robinson was still fundamentally about conviction.
Right. I'm not saying that it wasn't, because it went to trial and they litigated the DNA and the collection thereafter, and there was some confusion about when it went into CODIS.
And it was also, I believe, Your Honor...
I'm also saying, though, that language is unassailable. Well, I wonder how you ask us what we do with Robinson if we go with your rule about the identification issue not being protected by privacy.
Well, Your Honor, I think Robinson was also decided primarily as a Fourth Amendment case because it was coming up.
Well, why wouldn't that be part and parcel of what we consider under reasonableness for privacy, as the AG has recommended we do in this case?
Because outside of the exclusionary rule context, we have a whole line of this court's opinions that have applied a more exacting standard to arrestee searches and have required a closer connection to the asserted governmental interest, such that that allows a search only when the asserted governmental interests, be they jail security, officer security, actually come into play. To give one example, Lewa. The asserted rationale of the search there was a so-called accelerated booking search, because the search actually didn't occur at booking, it occurred in the field. So the state was arguing, well, this is an arrestee who's going to be booked anyway, so we can validate this under this accelerated booking rationale. This court said no. This court said a booking search is fine when you actually get to that point. Now, as applied to here, the asserted governmental interests under the rationale of the King opinion all really come into play if the person is actually going to be charged and go through the judicial process.
So I'm not quarreling with how you interpret that particularly, but to the extent that the argument is that we don't follow King because the California privacy interest in our Constitution can be construed to be more protective, which I also don't disagree with. I wonder what you say about our Robinson case, where we have said, this court has said, and not too in the distant past, that an individual in lawful custody cannot claim a privacy right in their identification. Would we have to walk back from that language in order to side for you in this rule?
I don't think you have to walk back from that, Your Honor, because King was coming up in a Fourth Amendment context. King, whatever the breadth of that language, was specifically considering the legality of a search based on conviction, as opposed to, I do not believe King was evaluating the legality at the arrestee point.
You mean Robinson?
Well, I'm sorry. I'm sorry. Yes, I do, Your Honor. Yes, I do.
So in the end, it sounds like you're saying that even if there's stray language in there, it's about arrest, the core of the case and the holding is about conviction.
Yes, Your Honor. And it's also
About the Fourth Amendment.
Exactly. Whereas we know that not only does Article 1, Section 13 been construed as more protective, but uniquely in this case, as also discussed in the Court of Appeal opinion, this court's construction of Article 1, Section 13 should also be informed by the fact that California has this separate, explicit constitutional protection for privacy, which the core object of which is informational privacy in protecting the citizen against the stockpiling of highly private information in governmental databases. Now, this was adopted in the 1970s at an era in which technology seems eons behind where we are now. But the drafters of that initiative and the electorate that adopted were prescient in understanding where this was going and the type of threat to privacy maintained by what we have here, which is that these tens of thousands of people who are arrested but aren't ultimately convicted, and a very substantial portion of them aren't even charged, are going to have their DNA submitted to the DOJ laboratory, and though there is nominally an expungement process out there, I would commend this court to consider the Professor Elizabeth Joe's law review article cited in our pre-argument letter, The Myth of Fingerprints, and also the amicus brief of Electronic Frontier Foundation, which, based on a pre-publication citation of that same article, has a very helpful chart showing how illusory expungement is as compared to in California.
Counsel, let me ask you one last question. Does the rapid DNA technology and the 2017 Federal Act change at all the discussion we are having?
I don't think it should, Your Honor, because this court has to evaluate the system and place at the time. And certainly at the time, there was not rapid DNA technology being applied. And in fact, DNA was not being used in California for identification in the traditional sense of the word, and it's not being used today. Maybe a decade from now it will be, maybe even earlier than that, but that's not the situation today. The other comment I would make, which is a broader one, implicated by the advent of new technologies, is new technologies are great in the sense, from a law enforcement point of view, that they put huge amounts of additional private information can be obtained and so readily at lesser costs with less labor-intensive means.
But Justice Liu asked you the question: is when you balance the government interest, is the government interest in knowing who they're dealing with, Is this a violent felon? Is this a person that needs to be segregated in the prison system? Is this a individual that should not be permitted to go out on bail because of the information that the government gains from the rapid DNA technology? Isn't that booking information that we have to balance when we look at the government interests in going through this process?
I would disagree, Your Honor, because the notion that this curious expansion of identification to include unknown, unsuspected prior criminal conduct as relevant to jail classification or bail, that rationale is breathtaking and very troubling in its scope, because I see no principled basis on which the court, which law enforcement can take DNA, take one's, which involves a bodily intrusion, genetic material, that they can take DNA for this putative purpose of finding out that whether someone who doesn't have a criminal record nonetheless may have unknown prior crimes.
Isn't that?
Do you challenge the use of fingerprint identification for that purpose?
No, I don't, Your Honor, because fingerprints are the ideal identification tool because they reliably and uniquely identify the person and, in fact, are used for that purpose. But in contrast to DNA,
That coming into question, it seems to me that the DNA analysis is much better than fingerprinting. You can change the color of your eyes by using contact lenses. You can dye the color of your hair. You can have plastic surgery, but you cannot change your DNA.
but, Your Honor, fingerprints remain a reliable identifier despite someone who changes their hair, contact lenses, whatever. So fingerprints are the gold standard, and they don't expose all. They don't put in the hands of the
DNA
government.
analysis is more accurate than fingerprints?
Can
you change your fingerprints?
It is almost unheard of, Your Honor. It is such a.
Almost unheard of?
They're changing one's fingerprints, yes, Your Honor.
Really?
I mean, it is extraordinarily rare.
Well, I think the challenge to fingerprint evidence, at least outside the record, is that the analysis and comparison has proved to be imprecise, and we see Kelly Fry and we see Dober challenges to it. I mean, I don't think anyone could say that, well, that it's unassailable and it's ideal, although you on the record as a defense attorney is very interesting to me to say that. But I would just say, your position is it continues to be, it's ideal, it's perfect, it's superior to DNA testing?
The reason I say that is because the combination of that in virtually every case, it is going to serve as a unique identifier, but is not going to put in the hands of government all this sample containing all one's genetic data.
So if I could just sort of confirm what you're saying. What you're suggesting is that the government does actually have a legitimate interest in the correct identification of a detainee, including their criminal history, as revealed by fingerprints. What you're instead suggesting, if I understand you correctly, is that the DNA evidence, unlike fingerprint evidence, is potentially much more invasive of privacy, and so that is where the balance shifts. You're not denying the legitimacy of the government's interest in receiving information about this individual, including whatever criminal history their identification might reveal.
Well, and criminal history, of course, Your Honor, I do distinguish between criminal history in the sense of whether this person has ever been convicted before, whether this person has a criminal record, and the asserted purpose here of whether the person has some unknown, unsuspected criminal activity. Because let's call this for what this is. This is a warrantless, suspicionless, non-particularized search directed to the possibility of prior criminal wrongdoing unrelated to the crime of arrest.
I have to ask you about one piece of that sentence, though. Even if I bought most of what you said, suspicionless? Is that exactly right?
Yes,
That's
Your Honor,
not
because
quite
there's
right,
no
because
suspicion.
There's been an arrest.
Pardon?
So, I mean, there's been an arrest. So, are you going to tell me that we should, as a categorical matter of law, find that arrests don't reflect a degree of suspicion?
An arrest reflects an officer's belief in probable cause as to the crime of arrest. But there is no particularized suspicion that this person has engaged in any other wrongdoing. In every other context, because after all, there's
suspicion for the target offense.
Exactly,
Not
for
for
That's
the
the
arrest
key
offense.
distinction you're making, right?
Yes.
So
For
the
suspicionless
non-target
with respect to anything outside the scope of the basis for which a person was
Exactly, Your
Could I
Honor.
ask you, I think you were finishing an answer to Justice Kruger's question with respect to fingerprints versus DNA. With respect to the unsolved crimes piece of criminal history, is fingerprint used for that purpose?
Fingerprint use for that purpose is acceptable because fingerprinting is actually used for conventional identification purposes. And this is something, and the fact that fingerprinting is legitimately used to identify someone in the traditional sense. What's this person's name? What is his criminal history in the sense of a criminal record?
Why isn't it the same argument, though, which is to say, if the FBI or whichever state has a database of unsolved crime forensics, including latent unidentified fingerprints, and you collect Mr. Booza's fingerprints immediately upon arrest, and you run those prints against the unsolved crimes prints database, doesn't that raise the same set of concerns?
I don't think it does, Your Honor, because the reason the government has legitimately acquired the arrestee's fingerprints.
I see. I see what you're saying. So you're saying that the initial step of the collection and analysis is already shrouded with legality.
Yes, because it's a legitimate identification
And so in
search.
some sense, the unsolved crimes piece becomes an incidental use.
Yes, Your Honor.
Whereas in the DNA context, that's the sole use, really, because there's nothing else to be achieved by the DNA other than that.
That's exactly correct, Your Honor. And it's similar to what we have in other arrestee contexts.
Got it.
There are a variety of circumstances in which, for a purpose other than traditional crime solving, the police are allowed to conduct a search of an arrestee, for example, to prevent him from bringing contraband or weapons into jail. That is a legitimate security purpose that is not dependent on a suspicion that he has a weapon and is for jail security.
I think you said that, so your concern, I think, in this context is, if we're concerned about criminal history, right, there are lots of ways to research criminal history that identify convictions, even arrests, I suppose. And all of that is through conventional means, records, rap sheets, et cetera. What we're only concerned about here, really, is a situation where a person manifests none of that, right? No criminal history. And yet, we are trying to find out something beyond that with respect to unsolved crimes.
And
Yes, Your Honor.
Mr. O'Connell, you may answer the question, but your time is long expired.
All right, Your Honor. What I find breathtaking about the notion that the identification also encompasses this, has someone done something unsuspected, is I don't see a principled way of distinguishing a search of one's genetic data for that purpose with a search of one's phone or one's home for the identical purpose that the phone, for example, the contacts list may correlate with a gang database, which would be helpful for jail classification, for search of a house. If weapons or drugs are found in a house, that would certainly be relevant to bail or an OR. We know that you can't search a phone or a home for those reasons. What I don't see is a principled basis for how you can distinguish these, because after all, the search we're talking about here is a core constitutional protection because it's a bodily invasion. It's one's genetic.
O'Connell, we have your argument well in mind.
Thank you, Your Honor.
Expired.
Could I start, counsel, with where we had left off? In response to Justice Cuellar's question about Terry stops, you said that would go too far, or at least you sort of suggested that would cross some sort of constitutional line. But then I asked you, well, why is 60,000, or I'm just using that as a marker. You can dispute the data if you wish, but I'm just using the marker. You said, well, that's not a constitution. Those are not constitutional facts. It would seem to me that if you thought that Terry stops are somehow constitutionally suspect, that certainly has to do with the notion that the level of suspicion is lower and the dragnet there is bigger. And so why qualitatively is not the question of whether or not probable cause should enter the equation also relevant in the very same way? It deals with the level of suspicion. It deals with the range of the size of the dragnet that you're setting up. And you could argue that 60,000 is the appropriate constitutional number, but it doesn't seem appropriate to argue that that's just not a constitutionally relevant inquiry beyond a certain point.
Your Honor, I think the answer to that question goes in part to what I was going to say to correct a few points about the questions you were asking about fingerprints. What we understand in this state and this society is that if you are arrested for, say, setting fire to a police cruiser and you are taken into custody, that the officials at the jail will collect and retain your identifying characteristics. And with respect to my friend, I don't think that the answer was quite correct with respect to fingerprints. Yes, it's true that since the 1990s, we can use them now to quickly confirm an individual's name at some future arrest. That wasn't an available use prior to the 1990s or at the time of this court's decision in Loader, and yet this court concluded that it was appropriate, in the face of a privacy clause challenge, to have those identifiers in government records. And yes, we do use fingerprints and query not just the known database, but the database of latent fingerprints from crime scenes. It just happens to be that fingerprints are not as precise, they're not as reliable, and there are many, many instances where we can get a DNA identification profile from a crime scene, but not a fingerprint.
Neither are fingerprints so informative about all the other aspects of somebody's background and, biological nature that DNA would reveal. So that surely weighs in the analysis, does it not?
That's exactly right, Your Honor. And if I could go back to a point that I think you made with respect to this court's decision in People versus Robinson, I think that's a very important precedent. I appreciate that it was deciding a Fourth Amendment question regarding the convicted offender provisions of the database, but it held that the very search at issue in this case, in that context, was minimally intrusive, relying on court of appeal authority, and those court of appeal cases had walked through all of the very robust restrictions and protections and safeguards and confidentiality measures that are baked into this statute that are instrumental to the balancing analysis. So I take the thrust of your question. There is more rich information in this biological sample that's collected, but we don't look at that information and we can't look at it. And so the net effect is a neutral identifier that is quite like fingerprints.
The United States Supreme Court in Birchfield versus North Dakota, which weighed the constitutionality of breathalyzers and blood tests with a DUI stop, in evaluating the blood test was looking at a statute that also had similar protections and prohibitions, and yet did consider the possibility of the use of DNA for purposes that were unauthorized in the balancing, didn't it?
That's right, Your Honor, but I think that Birchfield has to be understood in context. It didn't suggest that King was wrongly decided. What it did is conduct a comparative analysis for reasonableness, and the court said—
Should we do that with fingerprints and DNA analysis, a comparative or less restrictive alternative, as First Amendment analysis says?
I don't think so, Your Honor, because I think that the point in Birchfield that the court relied on was that officers can get the same blood alcohol content evidence from both mechanisms, but that a blood test is comparatively more intrusive than a breathalyzer. And here, as I just noted, a fingerprint is similar to DNA identification profile. It informs the balancing, but the DNA profile is far more precise and accurate and a much more powerful tool for serving the range of legitimate government interests that are discussed in King and in Loader by this court.
Is it possible to get a DNA analysis from a fingerprint?
Yes, Your Honor. In certain circumstances, if biological material comes off of the fingerprint, and sometimes at crime scenes you get touch DNA, you could get a DNA identification profile. I think back when we had cards that tin prints were taken on, those probably all involve biological material that's still attached to them. Of course, we presume regularity and good faith, and that government officials are not mining that information for improper purposes, and they certainly aren't doing it under the voter-adopted DNA provisions for arrestees, which serve some very powerful government interests.
Can I ask you about the contingent legislation?
Yes, Your Honor.
First of all, it seems unusual that the legislature adopts contingent legislation, is it not?
It is an unorthodox statute.
Does it not at least suggest that a co-equal branch of government senses some weakness, constitutionally speaking, in the statute that has been adopted?
That's not how I read it, Your Honor. I think that this is evidence that a co-equal branch of government thinks that this is an extraordinarily important policy. Of course, the Court of Appeal did conclude, we think wrongly, that it was unconstitutional. And if the court looks to the statement of purpose for that statute, I think it's clear. The legislature is not saying that we think this is an ideal policy or the best policy. They're saying we want to have a fallback policy in place in the event that this court affirms the Court of Appeal.
Even the act of anticipating a fallback policy just seems like it's a little bit, it's at least sensing that there is a real issue here. You don't need to go further with that. I mean, there may be nothing to it. I just want to know what you think is lost from a policy perspective. There's no disputing, I think, that the contingent statute would bring this much closer to King. So what is lost?
Well, as a practical matter, and this, I think the aspects of the contingency statute would be quite difficult and cumbersome to implement. Of course, if that becomes a law, we will do it, Your Honor. But with respect to the provision that delays the processing of the sample until after a probable cause determination at an arraignment, then that, of course, would mean that we couldn't possibly get that information before arraignment to inform the decisions that are made at that point of the criminal process. And I think that points up why.
How many days is that, you think?
Well, Your Honor, it depends. So if an individual is in custody, then the arraignment is going to happen quite quickly. We point to data from Orange County that indicate that at present time, a lot of arraignments happen out of custody. In Orange County, more than 40% of felony arrestees are arraigned out of custody, on average more than 35 days from when charges are filed. And at present, our DNA lab is able to process DNA identification profiles from arrestees on average a little bit less than in 18 days.
Speaking of practicalities, counsel, you've several times mentioned the safeguards in the statute as being important in the analysis. This is, after all, balancing under your analysis. So is it important at all whether the government conveys clearly that expungement is available to arrestees and makes that process quite feasible and easy versus just whispering to them that expungement is available or not saying anything at all about it?
Well, Your Honor, I don't think it makes a difference to the constitutional analysis, but if I can push back a little bit on the premise of your question, we have tried to
just a little.
we have tried to publish this. It is available on the internet. If you search in any Google browser DNA and expunge, if you're in California, when I did this, it comes up on the top hits. We have posters that are in Spanish and English about this that we push out and encourage people to put in booking stations. And in requiring qualifying arrestees to initiate expungement, we have the same policy as the federal government and I think 17 other states. And that's the same policy we have with respect to fingerprints and photographs and other identifiers.
Helpful to know this, but your sense is that this does not matter for the constitutional analysis.
I think it doesn't matter because courts have pretty routinely held that there is not a constitutional right to expungement of an identifier collected, at least at a lawful custodial arrest. Now, I think that it is relevant in the sense that this is, in a sense, an additional protection. We do have an expedited expungement mechanism. We make it available. It's actually far more straightforward, I think, in some respects than how you get expungement of fingerprints and other identifiers. And so, if anything, that weighs in the balance in favor of reasonableness, not against it, Your Honor.
Thank you, Mr. Mongan.
Thank you.
Time's expired. Thank you, counsel. The matter is submitted. We stand in recess until 1:30.